David Ayande. 10. Augustine Obutel. 11. Godfrey Iche. And 1. Obudu Mountain Resort. 2. Proti Hotels Obudu Ranch. 3. Mr. Julius Machi, Acting General Manager, Obudu Mountain Resort. 4. Mark Frank Abo, Senior Advisor on Obudu Mountain Resort to Government of Cross River State. My Lord, all the parties are absent.
Appearance.
May it please, Honorable Court.
Yes.
AOB appear for the claimant, sir. Hello, we are sorry for our belated appearance, my lord.
All right. Any other appearance?
My lord, defendants are all represented, man.
This case is for judgment. The judgment of the court is ready.
My lord, the business of the court permits us, we are ready, sir.
This is the judgment of the court. The claimant commenced this suit by the general form of complaint dated 9th of June 2022 and filed on the same date. On the 25th day of October 2023, this court granted leave to the claimants to amend their general form of complaint and its accompanying processes. The claimants are by the paragraph 61 of the amended statement of claim by the statement, paragraph 61 of the amended statement of facts, claiming jointly and severally against the defendant as follows: a declaration that the purported termination of claimant's employment on ground of age without recourse to 3-month notice in lieu of notice is contrary to the conditions of service as well as employment. B, a declaration that the claimants are entitled to 3-month salary in lieu of notice of termination of employment. C, a declaration that the claimants are entitled to the financial benefit as contained in the conditions of service, as well as other instant laws regulating employer-employee relationship. A declaration that the inability of the defendant to pay claimants their financial entitlement, including retirement benefits, as contained in the communique reached between the defendants and the two unions as representative of the claimant, constitute a fundamental breach. A declaration that the defendants are bound by the resolution reached between the defendant and the two unions as representative of the claimants as contained in the communique issued on the 8th of July 2020. An order directing the defendant jointly and separately to comply with the said resolution as stated in paragraph E and pays the claimant their entitlement contains a resolution including not limited to retirement benefit as gratuity as contained in the resolution reached between the defendant and the two unions as representative of the claimants as contained in communique of the 8th day of July 2020. After an order of this court directing the defendant jointly and separately to pay the claimants each 3-month salary in lieu of notice in compliance with the conditions of service and other financial benefit, including leave grants that accrues to the employment. H. An order of this honorable court directing the defendant jointly and separately to pay claimants each the sum of 20 million naira as only as general and aggravated damages for breach. I. An order of this honorable court directing the defendant to jointly and separately pay to the sum of 20 million only as cost of this action. The defendant in this suit, despite having been served with the originating process commencing this suit and hearing notices all served through postal service, neglected to enter appearance and file defense to the claimant's action. This action was fought based on the claimant's processes as the defendant refused to honor the invitation extended to them by the court to appear and defend the case. Hearing in this suit commenced on the 13th day of July 2023, with the second claimant testifying as CW1. CW1 adopted his statement on oath on 9th day of June 2022 as his evidence in this case. The letter of appointment was admitted in evidence as Exhibit C1. Other documents were tendered through this witness and they were admitted in evidence as Exhibit C A to C.
This is the simple one.
CWA, or C1 to C7.
The simple one. How much is that?
The cross-examination of the witness came on the 5th day of March 2024, but the defendant refused to appear in court and cross-examine the said witness. On the 5th of claimant testified, fifth claimant testified as CW2. He adopted his witness statement on oath and as his evidence and tendered 4 documents in evidence. They were admitted and marked as Exhibit CW and marked as Exhibit. The third claimant testified also as CW3. He adopted his witness statement of oath and also tendered documents which were marked as Exhibit CW3A to CW3D. On the 24th day of April 2021, this matter came up for cross-examination of CW3. The defendants were not in court and not represented by counsel. The post claimant testified as CW4, adopted his witness statement on oath and tendered document and evidence which were marked as Exhibit CW3A to CW3D. On the 25th day of April 2024, the sixth claimant testified as CW5. He adopted his witness statement on oath and also tendered documents which were marked as Exhibit CW4A to 4E. The ninth claimant testified as CW6 and CW6 adopted his witness statement on oath as his evidence. In this case, 3 documents were tendered in evidence through CW6. They were admitted in evidence and marked as Exhibit CW5A to CW5C. Also relied on the document tendered in evidence through CW1. On 29th day of May 2026, the 7th claimant testified as CW7, adopted his witness statement on oath and tender documents which were admitted as Exhibit CW6A to CW6D. On the 30th day of May, the first claimant testified as CW8, adopted his witness statement on oath as his evidence. In this case, 4 documents were tendered and admitted in evidence through CW8. The documents were marked as Exhibit CW7A to CW7D. On 1st of July 2025, the 7th claimant testified as he adopted his statement of oath and he tendered documents which were admitted as Exhibit CW9A to CW9B. On the 18th day of December 2025, the claimant closed their case and they were ordered to find a written address since the defendants have not entered appearance or filed defense in the matter, and they were not represented by counsel. On the 4th day of March 2026, the counsel for the claimant adopted his final written address as address of the claimant's file on the 16th day of February 2026 as his argument, and adopted and urged the court to grant the relief sought by the claimant in this case. The case of the claimant. I will skip reading the case of the claimants. It is captured in the body of the judgment. The submissions of counsel, A or AB Esquire counsel for the claimant adopted his final written address as his argument in this matter. 3 issues were formulated for determination. The argument on the 3 issues have been captured in the body of the judgment. So I will skip reading the submissions of counsel as per the 3 issues formulated. I now go to the decision of the court. I have considered the claimant's general form of complaint and its accompanying processes, as well as the written and oral submissions of counsel for the claimant. The defendant in this suit, despite having been served with the originating process commencing this suit and hearing notices all served through postal service, failed and neglected to enter appearance and file defense to the claimant's suit. This action was fought based on the claimant's processes, as the defendant refused to honor all invitations on entreaties by this court to appear and defend. In an attempt to prove their case, the claimants called a total number of 8 witnesses who testified in proof of the case put forward before the court. The witnesses adopted their respective witness statement on oath. They have also tendered documents in evidence which were admitted and marked as exhibit. The case of the claimant, as can be gleaned from their processes before the court, are to the effect that they were employees of the first and second defendant, and that in the course of their employment, following the outcome of departmental personnel audit exercise conducted on the 18th to 20th day of May 2020, the claimants were disengaged from the service of the service of the first defendant with effect from 1st July. The claimant were disengaged without notice of payment in lieu of retirements contrary to the conditions of service, without provisions of 3 months salary in lieu of notice. The defendants have refused to pay claimants their benefit despite agreement to pay so on or before 31st of December 2021. The issues that need to be resolved is whether, having regard to the facts and evidence before the court, the claimants have proved entitlement to any of the relief sought. Before delving into the determination of the issue identified, I shall endeavor to deal with the issue of international best practice and that of statutory labor raised by counsel for the claimant. There is no doubt that this court has requisite jurisdiction on international best practice. However, for the court to be able to utilize its powers of applying or enforcing international best practices, the party wishing the court to invoke its power in his favor must be able to plead facts and adduce evidence of the international best practices which he wants the court to establish. This is because the question of international best practices is a question of fact and not law. See the case of College of Education, Zinc, and others versus M. Creed, reported in 2025 LPELR H2762CA. I have scrutinized the facts and evidence of this case. Nowhere claimants have pleaded facts amounting to international best practices for the court to apply to the case at hand. On the statutory labor, counsel for the claimant has argued that the claimant's case is one of statutory labor because the government of Cross River State owned the second defendant. On the defendant in this case, the mere fact that the law is that the mere fact that an employer is creation of statute, or that it is statutory corporation, or that the government has shares in it does not elevate it to employment into one, does not elevate its employment to that of statutory labor. Rather, there has to be a linkage or nexus between the employments or between the employee's appointment with the statute creating the employer or corporation. See the case of Power Holding Company of Nigeria Limited and Opelo, and the case of Controller General of Customs versus Gusau cited by the claimant. For an employment to enjoy statutory labor, the manner of employment and termination must be specifically provided for in the statute creating the employment. See the case of FMSC versus Ido Ekiti versus Olajide, reported in 2011 Nigerian Upload Report 1258, page 256. In fact, it has been held that the fact that an appointment is pensionable or made by a statutory body does not mean that the appointment enjoys statutory protection or is one that enjoys statutory labor. See the case of Imolome versus WAEC. See also the case of Jirga versus Union Bank of Nigeria PLC. See also the case of NEPA versus Adasa. See also the case of Elau Bichi versus Phillips. In the case at hand, the claimants have not pleaded that their employment has statutory labor, nor have they tendered rules and regulations governing their employment, apart from their letters of employment and communique issued at the end of a meeting. In the circumstances, I have no difficulty in coming to the conclusion that the claimant's employment is not one that is having statutory labor. Coming to the main issue for determination, that is whether the claimants have, by the facts of and evidence before the court, proved entitlement to any of the relief sought. It has been established by a long line of decided cases that the burden of proof in civil cases like the case at hand rests always on the person who asserts. Therefore, the burden of proof in this case rests on the claimants who have asserted facts which is based on which they want the court to give judgment in their favor. It is when the claimants have adduced sufficient, cogent, credible, and admissible evidence establishing their claim that the burden shifts to the defendant. This is because the burden of proof in civil cases or matters is not static and may shift in the course of proceeding in a case, depending on the state of pleading at various stages. The initial evidential burdens of introducing evidence to prove a claim of a legal right or liability based on assertion of fact upon which the right and the liability is claimed is placed on the claimant and until it is satisfactorily discharged on the balance of probabilities or preponderance of evidence as required under Section 134 of the Evidence Act as amended. It does not shift pursuant to Section 133 of the Evidence Act. In this case, the claimants are the ones that desire this court to grant judgment in their favor. Therefore, the claimants bore the initial burden of proof in proving facts they asserted and on which they base their claim to judgment for judgment to be entered in their favor. See the case of Adegoke versus Adibi. See also Abu versus Inaji. Onwuma versus Ezokoli, Onwubare versus Onwohu, and Ike versus Obuaha, and other host of other cases cited therein. In the case at hand, the defendant failed to enter appearance and file statement of defense despite being served on them of the originating processes commencing this suit, as subsequent hearing notices on them. The defendant ignored all the invitation for them to enter appearance to and file defense to the claimant's action. The conduct of the defendants in refusing to honor the court processes served on them clearly shows that they are not interested in defending this case, or that they do not have any defense to the case of the claimants. The scenario that played The non-filing of the defense by the defendants means that they are not contesting the case of the defendant. In other words, all the claimants, armament, and evidence laid at the trial are uncontroverted and unchallenged. The implication in law is that the defendants on record are deemed to have accepted all the armament contained in the statement of fact as true and correct. Therefore, the facts facts not challenged or controverted are deemed admitted. See the case of Okoibo versus Police Council. In the circumstances of this case, this court is only grappled with the case of the claimants as same is as there is no defense filed to dispute what the claimants have averred and no legal representation at the trial have to cross-examine the claimants. In Okoibo's case, to BJSC of blessed memory has this to say. In this matter, the only case before the learned trial judge was the case of the appellant. In law, he can stand or fall by his case. The respondent did not defend the action. In most cases where a plaintiff case is not challenged, he succeed. This is because the trial judge has no other case to deal with other than the case stated by the plaintiff in his statement of claim and oral evidence. His lordship continued at page 473, paragraphs 8 to 8, though the basic principle of law is that where a defendant fails to file defense, he will be deemed to have admitted the claim or relief in the statement of claim. But where a paragraph of the statement of claim is notoriously false to the common knowledge of the court, like 10th of July in Nigeria is independence anniversary, such a paragraph is not admissible because it is an obvious untruth. And in the case of a said Simba versus Onwuzuruke, the apex court held that where the only pleading filed in the statement of claim, absence of statement of defense means no issue is joined between the parties. Per Iwala JSC of blessed memory. Therefore, the defendant's failure to file defense to claim of the claimant means they have no defense to the claimant's claim before the court. The action of the defendant is tantamount to an admission. It is tried to know that facts admitted need no proof. See the cases of Akalil and Sons versus NDIC, Sepik Nigeria Limited versus PBW Limited, COAN Overseas Agency Nigeria Limited versus Brownwayne Energy Trading Limited, and host of other cases cited therein. The defendants failure or neglect to file statement of defense and have by their conduct or failure to file defense admitted the abatements of the statement of claim which are left unchallenged and uncontradicted or uncontroverted. See the case of Huawei versus Medioa Nigeria Limited. See also the case of United Nigeria Insurance Company versus Universal Commercial and Industrial Company. See Akibu versus Otiduta. In the circumstances, the law does not require proof of impliedly admitted fact, and where proof is even required, is only a minimal evidence that would do the necessary groundwork. See the case of Balogun versus UBA. See also Ebunike versus ABC. See where the court in such circumstances has no choice or option but under an obligation to accept same as correct position of what the claimant has presented. See America Cyanide Company versus Vital Pharmaceutical. See also Yusuf versus Ilori. It is the law where a claimant files claim raising allegation of fact against the defendant or one of them, such defendants who does not admit the truth of the allegation must file a defense to contradict, controvert, challenge, or deny the allegation. In the case at hand, the defendant failed and neglected to file defense. By operation of law, they are deemed to have admitted the assertions of the claimant, and the court may preemptorily enter judgment against the defendant. See the case of Ajibade versus Maiwa, Oke versus Ayedun, Mashud versus Bayero, and Emodi versus Emodi. where minimal proof is required, save where minimal proof is required. There is the cases
Extension there. Extension. Extension there.
The cases where minimal proof is required are exception to the general rule on deeming facts admitted. This arises where there are reliefs that borders on declarations or claim for special damages. In such situations, the law does not allow grant of declaration based on weakness or absence of defense, as the claimant in such situation must rely on the strength of his case and weakness and not weakness or absence of defense. In the case at hand, since some of the reliefs being sought are declaratory, the claimant will succeed on minimal proof. See the case of Azenebo versus Bayero University, Kano. A cursory look at the pleadings and the evidence of the claimants will show that the first, second, third, fourth, fifth, seventh, eighth, ninth, and tenth claimants were retired on ground of age or inability to pay salary due to COVID-19. According to the claimants, they were disengaged with effect from 1st of July 2020 without notice or payment of 3 months salary in lieu of notice. They were also not paid gratuity or pension. I note the claimants did not tender any rules or regulations or conditions of service governing their employment, if, apart from the letters of employment committee report on personnel audit exercise conducted from 18th to 20th May and communique issued at the end of a meeting between the represented unions unionizing the claimants and the test defendant. I note also that attached to the exhibit C5 is a document titled Staff Terminal Benefit as at 2019. It was prepared on 25th day of February 2019. It also contained terminal benefit of 144 listed staff as at 2019. Let me make it clear that in all cases of employment, the condition of service is the paramount document to be considered in determining rights and obligations and liabilities of the parties. Therefore, in all contracts of employment, courts have been cautioned and must be wary of looking outside the terms for the terms governing the relationship between the parties and the employer, and where the terms spelled out the unambiguously how and when termination of employment can take place, and the termination is carried out in the manner provided by the terms that termination is not wrongful. Parties must be bound by their contract, and to look outside the terms of the contract is to avoid termination makes no meaning of the contract. Apart from those employment governed by statutory provisions, e.g., employment in civil service of statutory bodies, statutory bodies, or where termination must follow the provisions of the relevant statutes, Olanium versus University of Lagos, Epereku versus University of Lagos. The master in others cases, that is, master and servant can be terminated for good or for bad reasons, subject to the remedies of compensation where applicable for wrongful dismissal. The general rule is that where the parties have embodied the terms of their agreement or contract in a written document, as it was done in this case, extrinsic evidence is not admissible to add to, vary, subtract from or contradict the terms of the written instrument. See the case of Olawe versus Balogun. See the case of UBN versus Ozigi, where the parties enter into a contract, they are bound by the terms of the contract, and it is unfair to read into such contract the terms on which there was no agreement between the parties. See the case of Abdullahi Baba versus Inkat, Zaria, and another. In the case at hand, the claims of the claimants, borders or retirement entitlement on grounds of age and disengagement on ground of COVID-19 pandemic. As pointed out earlier, an employer has the right to disengage employee, but must comply with the rules and regulations governing such employment. For such termination or disengagement to be valid. As pointed out earlier, the claimant, apart from letters of employment which spelled out terms of employment, did not tender the conditions of service governing the employment. They have also tendered communique and report on personnel audit, which was the basis of their disengagement from service. From the various letters of employment tendered by the claimants, their services can be dispensed with by giving 1 month notice or salary in lieu of notice. The case of the claimants, as presented by them, by some of them, were disengaged on age ground and some inability to pay salary due to COVID-19. For those disengaged on age ground, the law is clear that once an employee is due for retirement other than age ground or on number of years in service, the employee once he clocked the age or the period of service has expired, whether he tendered letter of retirement or not, he is deemed in law to have left the service This means upon reaching the retirement age or serve for the number of period allowed by the rules, the employee must vacate his position as he is no longer in service due to age or number of years of service in the public service. It is usually service, it is usually serving for 35 years or reaching the age of 60 years, whichever is first that is applicable to public employees and also some private organizations. In the case at hand, the first, second, third, fourth, fifth, seventh, eighth, ninth, and tenth claimants were said to have due been due for retirement before year 2020, i.e. from 2005 to 2019. Among the 11 claimants on record, only first, second, third, fourth, seventh, eighth, and 11 claimants testified. This means fifth, eighth, and ninth claimants have abandoned their cases. Now, the questions that need answer is, can communicate Exhibit C5, which the claimant are relying heavily on the basis of their claim, come to their aid in the absence of conditions of service. What is a communique? A communique is generally defined as an official public statement, bulletin, or record which or record or record or record of agreement such as joint communique release after the meeting of government officials, unions, or corporate bodies. Therefore, a communique can be treated as a piece of documentary evidence. Its evidential value will depend on its evaluation by the court. Its legal status depends entirely on how it was created, its content, and what you are trying to prove. A communique is usually viewed as a summary statement of discussion issued at the end of a seminar, annual general conferences to outline stance on national issues. It can also be viewed as a statement issued at the end of government meeting on policy and adoption of the resolution. It is richly considered a legally binding contract. However, as in every general rule, there are exceptions. For instance, if a joint communique specifically states that party A and B have agreed to settle their dispute, pay a specific sum of amount, or perform a specific duty, it can serve as secondary evidence of a binding agreement. To claim a right based on this, and the party wishing to take advantage of the provisions in the communique must establish that the document contains all the essential elements of a valid contract after acceptance, consideration, and intention to create legal relations. Also, if the opposition party signed signed or issued a communique publicly admitting to a fact, e.g., admitting they owe a debt or are responsible for an action, that statement can be considered as a declaration against interest. I have thoroughly examined Exhibit C5, the communique issued at the end of the meeting between the first claimant, between between the claimants, between the representative of the claimants, that is the two trade unions, and the first defendant. It is clear to me that the content of Exhibit C5, that is, first defendant has unequivocally agreed and resolved to settle financial matters in respect of aged staff or retirement, redundancy, probation, contract, and 30% salaries deduction. I also note that the acting general manager of the first defendant, who is the third defendant in this case, is also a signatory to the communique. I also, as well as the chairman of the two trade unions representing the members of staff of the first defendant, in the absence of any evidence to contradict and controvert the content of Exhibit C5 from the defendant, I accepted Exhibit C5 to be binding on the first defendant and as modifying the conditions of service as contained in the letter of employment of the claimant. In the circumstances, I have come to the irresistible conclusion that the first, second, third, fourth, fifth, seventh, and 11th claimants who testified before the court and who tendered their letters of engagement, harmonization, and promotions are entitled to be paid their terminal benefit as contained in the document titled Terminal Benefit as at 2019. The first claimant listed as from the documents from Exhibit C5 and the document attached thereto, the first claimant was listed as number 19 on the terminal benefit list, and it was stated that he is entitled to 2,093,174 naira 40 kobo. He was listed as 19. For the second claimant, was stated that he's entitled to 5,146,869 naira 72 kobo. He was listed as number 92 on the list. The third claimant was said to be entitled to 2,627 naira 418 kobo, 418 naira 47 kobo, listed as 37th 37 on the list. The first claimant is said to be entitled to 3.82327,175.44, listed as 100 on the list of people entitled to terminal benefit. The fifth claimant was listed as number 63 with the sum of 3,516,000. Sixth claimant was listed as number 99 with the entitlement of 1,566,171 naira 81 kobo. The seventh claimant was listed as number 20 and is said to be entitled to 1,807,121 naira 40 kobo. 11th claimant was listed as number 89 and the sum of 12,337,769 naira 44 kobo listed as his entitlement. The first defendant has admitted the entitlement of the claimant as per Exhibit C5. In the circumstances, the claimants are entitled to their claims as per Exhibit C5, and the defendant is hereby ordered to pay the first, second, third, fourth, fifth, sixth, and 11th claimants the amount stated as per this judgment to be their entitlement. For the claim on 3-month salary, it fails due to failure of the claimant to prove entitlement to it, or where it was provided in the rules and regulations that make provisions for such payment. The claimant in whose favor this judgment is made are entitled to general damages, which I assess in the sum of 500,000 naira for each one of them who have testified and against whom I made an order for payment of certain amount of monies, which they were shown to be entitled to as per the terminal benefit tabulated by the first defendant. The claimants have not proved entitlement to cost of 20 million, as no evidence has been shown has been adduced before the court to show that the claimants actually spent the sum of 20 million in prosecuting this case. This relief same is hereby dismissed.
Away.
From all I have been saying above, the claimant succeeded in fact as per the judgment of this court, and as per the judgment of this court entered hereby accordingly. Before I end this judgment, I must say that it is clear to me that the reliefs being sought by the claimants were not elegantly drafted. That has contributed in the claims of the claimants, and also not having been granted certain reliefs due to the way and manner the claimants were drafted. In the final analysis, judgment is hereby entered accordingly as per the terms stated above. Registrar.
Very well, my lord.
Registrar.
Very well, my lord.
Yes.
Yes, my lord. My lord, we thank my lord for a well painstaking judgment this afternoon. My lord,
Yes.
a well considered judgment, research judgment.
It's
My
all
lord,
right.
no wonder we are elevated to the court of appeal. We pray
It's
to
all right,
be the court
yeah.
of appeal, sir. We
Amen.
thank my lord, sir.
You are welcome.
Lord, thank you, my lord.
Registrar. Yes, counsel, we have come to the end of today's proceeding. Thank
Yes,
you
sir.
very much.
We thank my lord, sir. And we take our bow, my lord. Chairman, we have come to the end of the court. The court shall rise. The court shall rise. The court shall rise. Yeah.